The topic is, as Karen mentioned, is looking at the rights that workers have in Australia, and perhaps drawing certain examples in terms of migrant workers or workers, whether it be on temporary visas or permanent visas, or who are actually citizens. And what I'm planning to do is really, in the next 20 minutes or so, really draw upon a presentation that I actually used last year, but actually is really a highly effective one that was developed by the Fair Work Ombudsman to sort of give you a sense of the sort of the rough lie of the land in terms of the laws that apply in this area, and then really hone in to particular entitlements that workers have in this country in terms of pay and as well as conditions. Talk about certain common issues that arise, including affecting migrant workers. Questions regarding pay slips or questions in terms of pay deductions and so on and so forth. And if I have time, I might take you to the Fair Work Ombudsman website, but let's see how we go. Now, the first point to be made is that all workers in Australia are protected by these laws. So put it in a negative way. There are no exclusions in terms of migrant workers or even asylum seekers and so on and so forth. If you're a worker, or put in a more technical way, if you're an employee at law, you have certain rights that are protected by law, specifically what's called the Principal Industrial Statute at the federal level, the Fair Work Act. You're protected in terms of the pay you should be receiving. So you'll see shortly that there are actually standards in terms of the minimum wages that you're entitled to. But you're also protected in terms of other aspects of working conditions. Leave, annual leave, personal leave, and so on and so forth. As well as, broadly speaking, protection against what might be considered arbitrary and unfair treatment at work, including discrimination. And this, in a way, will link up to some of John's talk. Now, when you think about the system, it is a complex system, but I think it can be reduced to certain essentials. One is that, in terms of the laws and the regulations, it's useful to conceive of them as based on a certain hierarchy of regulation. When I mean hierarchy, what I mean is that there are certain laws that actually take priority over others. So what is the foundational laws in this area? The statute that I mentioned, the Fair Work Act, really is the most important set of laws in this area. But what you find in really any employment relationship is that the working conditions that you would have are not just governed by the Fair Work Act or its regulations, but are governed by these things called industrial instruments. Now, it's a big technical term, but it's actually not that difficult to understand. One is that the Fair Work Act empowers an institution called the Fair Work Commission. So it's an independent institution, is sometimes what's called an industrial tribunal, and that tribunal lays down certain standards that apply on an industry level. Now, these standards, it's a bit of reflecting Australian history, are called awards. So you have, for example, a hospitality industry award, governing people who actually work in hotels and so on and so forth. You have a restaurant industry award that also deals with people who are waitering or waitressing. Actually, just to get a sense, can you throw up some occupations they are working in? Then I'll give you an example of some awards. Or what industries you might be working in. Anybody working in retail? No? Anybody working in, sorry, yes? Retail? No, sorry, I was back. Anybody working in a fast food industry? So you got a fast food industry award, which actually is separate from the restaurant industry award. Anybody working in a university? So there's a higher education industry award and so on and so forth. There's anybody working as a cleaner? Cleaning services award, so on and so forth. Okay. So when you think about it, it's not difficult. The Fair Work Act applies lays down national standards. Yes? All right? So different states, different territories, different industries, different occupations, they're all covered by the Fair Work Act. But the awards apply at an industry level. So it depends on what industry you're working at. Yeah? So that's one very important set of industrial instruments. Now, the other industrial instrument under this regime is an enterprise agreement. The awards apply at an industry level, but what you can have in some enterprises, enterprise, big fancy word, all it simply means is a company, yeah, okay? In any company is that a company can actually make an agreement with its workers, yeah, or often make an agreement with the union representing the workers. And if that agreement is made, that agreement will displace the award. Displace meaning in the sense that, rather than the award applying, it will be the enterprise agreement, as in your example, yeah? But an important condition for the enterprise agreement actually displacing the award is that it needs to satisfy what's called the better off overall test. Yeah? Now, better off overall test. Again, the test is what it means. Yeah? So, in the example you had, the award actually said that if you work Sunday, you get higher rates. Yeah? Now, in the agreement, you got lower rates for Sunday, but the point to be made here, why the agreement has still legal effect, is that the base rate is actually higher. So the workers should be left better off overall, yeah? Even though they're being paid less on a Sunday. Now, the third one is something you all will be probably much more familiar with. This idea is an agreement, yes? Yeah? So any employment relationship will be based on an agreement between the worker and the employer, yeah? And the legal form it takes is a contract of employment. Yeah? And that contract of employment can deal with, sometimes it can be very informal. Informal in the sense actually it can be a completely verbal agreement. Yeah? So verbal agreements can be contracts too. Or it can be very comprehensively documented in terms of a written document. Yeah? Yeah. Now, the key thing to stress here, you're thinking about this hierarchy, is that the contract of employment is subject to those other instruments. Say, for example, we'll see shortly that under the federal legislation, the minimum wage is a bit over $18. Yes? But you sign up a contract, and the contract provides for only $14 an hour. The contract is void in the technical way, technical sense, is void to the extent it's inconsistent with all the other instruments. Yeah? So another quick example, all right? You're working in the restaurant, you're working in a cafe, just close by, yes? And the award that applies to it is the Restaurant Industry Award, yeah? And say, I'm plucking a figure here, yeah? Okay? Let's say the Restaurant Industry Award says that on a Sunday, if you work on a Sunday, you're entitled to be paid $24 an hour, yeah? All right. But your boss says to you, hey, we're going to pay you $20 an hour. What are you entitled to? 24. That's right. Yes. Okay? So it's a very important point in terms of labor standards. Yeah? Labor standards are standards. Yes? You cannot opt out of labor standards. Yeah? They are standards for the community, whether set on a national scale, or industry scale, or on an enterprise level. Yeah? So the boss can't say to you, hey, you agreed to this, yeah? Okay, you agreed to $20 an hour, so what are you complaining about now? Yes? It comes back to a point in the earlier slide. These are rights protected by law. Yes? Okay, let's come to a little bit more of the detail, and I'll run through some of this quickly, yeah? So under the Fair Work Act, there are certain rights protected in terms of the conditions of work, and they're found in what's called the National Employment Standards. Yeah? Okay? There are standards in terms of the maximum weekly hours for jobs. It doesn't quite mean what it means. What it typically tends to mean is that if you work above 40 hours a week, you should be getting some kind of overtime. Yep. Not that you could be prohibited from working more than 40 hours a week. Yep. Right to request flexible working arrangements. So this really deals with people who have caring responsibilities. So they have an ability to actually request to work. For example, if you've been full-time and you became pregnant and you wanted to return to work on a part-time basis to care for your child, there's a right provided by law. The importance of this right is that the employer cannot refuse, can only refuse on reasonable grounds. Yeah? Yep, they can only refuse on reasonable grounds. Parental leave, 12 months unpaid parental leave, yeah, for workers that have 1 year of continuous service. It's hardly a generous entitlement, but it is there. Annual leave. Anybody want to tell me what the annual leave entitlement might be for a full-time worker? Yep, 4 weeks. Very good. Yep. Personal carers and compassionate leave. That includes what people refer to as sick leave. Yes? All right. So this is leave. With annual leave, what we see, as you all would know, is that you get 4 weeks for a full-time worker. You don't have to say, I'm going to be doing this to get annual leave. Yes? All right? You have to agree on the timing with your employer or your manager, but you don't have to say, well, you don't have to give a deserving reason. Yes? Whereas what you see with personal carers leave is that the leave is available because of certain circumstances. Yeah? So sick leave is an obvious example. You need to be sick to get sick leave. Yes? All right? And then a doctor's certificate might be required. Anybody want to throw in a number? Full-time worker, 1 year, how many weeks will you be entitled to? It's 2 weeks. This is paid leave. Remember, these are national employment standards, right? These are the standards according to apply across the country. But you, of course, may find that in enterprise agreements, they actually provide for much more generous personal leave entitlements. Community service leave, it's pretty self-evident in terms of what it means. Yeah. Long service leave. So this is, I think, now a very uniquely Australian entitlement. Yes. That generally speaking, if you work 10 years continuously with a particular employer, then you have, I think, 14 weeks paid leave. Yeah. Very uniquely Australian. Yeah. Public holidays. Yeah. Now, it's not so much that you can't be asked to work on public holidays. Yeah. But it's really about getting paid at an extra rate for working on public holidays. Notice of termination redundancy pay. So this is at the back end of things, yes? All right, so the National Employment Standards basically sets up with notice of termination that a scale that varies according to the number of years you've been employed with the employer. Yeah? It's not a terribly generous scale, but if you've been employed between 1 or 2 years, you should get 1 week service, and it goes up to 2 weeks for the next year, 3 weeks, and so on and so forth. Not terribly generous, yeah? Okay, but it's there nevertheless. So the idea being captured here is this. Redundancy is a situation where the position in which you're working no longer exists. Yeah? All right. So it's not to be distinguished from situations where you might have been dismissed because of misconduct, or you've been dismissed because you're not performing properly. Yes? All right? That's not a redundancy situation. Redundancy situations might occur, for example, when a company restructures and it says, let's say the university restructures here and says, hey, we don't need so many law academics, yes? Okay? And maybe John and our positions have been abolished, yes? And there's actually a scale, which is actually a reasonably generous scale in terms of how much redundancy pay you're entitled to that is tailored, is calculated according to the years of service you have. Fair Work Information Statement. You're all supposed to have received one. Yes? The Fair Work Information Statement, as the name suggests, is a statement basically identifying the key elements of what I've actually talked about. But I think it's pretty accepted that this obligation, which is on the employer, is on the obligation of the employer to provide any employee as reasonably as practicable a Fair Work Information Statement, that this obligation is probably honoured more in breach than in compliance, yeah? As we can see from this small sample that we have, yeah? Okay, let's move on. And awards, I think I mentioned to you about what awards do. They apply to different industry, yeah? And they go beyond what we just dealt with in terms of national employment standards. So they deal with what are called penalty rates. Penalty rates cover a whole range of situations, but they're basically about rates above the base rate, whether because you're working on the weekends, or you're working overtime, or you're working a night shift, and so on and so forth. Yeah? This is the national minimum wage. Yeah? And this national minimum wage is varied is invariably changed every year. Yeah? So every year, the Industrial Tribunal that I mentioned to you, the Fair Work Commission, has what's called an annual wage review, where it reviews the national minimum wage. Yeah? And since its establishment, it's increased the national minimum wage every year. Yep. So this is what you're entitled to in this financial year, 2017-2018, but it's most likely will go up from July 2018 onwards. Yeah. What you find is that, so this is talking about all employees are entitled to this national minimum wage, but what's also important, both in terms of pay, but also in terms of conditions, is what type of employment are you engaged in? Yes? All right. So one difference is between full-time and part-time, and the difference there is really about the number of hours, yeah, as you can appreciate, yeah. So what you find is that full-time gets the full entitlement, and part-time will get the entitlement prorated, yes. So if you get, generally speaking, let's say it's 38 hours a week, if you work half of that, you get half the entitlement, and so on and so forth, yep. That's pretty easy to understand. Now, the third category is a bit more complicated, is that if you're employed as a casual employee. So one is that it's about the length of your engagement, yeah? And sometimes you find that, and it varies, okay? I mean, all these categories are not homogeneous categories, yeah? They're not all the workers will have the same situations in all these categories. But with the casual, what you might find is that sometimes they might be employed on a very short-term basis, but you can also have what might seem like an oxymoron, long-term casuals. Who's worked as a long-term casual? Yeah, there'll be a few here. Again, there's about a third of the casual workforce in Australia could be considered long-term casuals, meaning 3 years or longer as a casual. Yeah? Okay. So one is your employment length of engagement is not guaranteed. It might be actually long in fact, but as a matter of law, it's not guaranteed. Yeah. Now the other two big differences are these: is that a casual employee does not receive the paid leave entitlements that we just talked about in terms of paid annual leave and paid personal and carers leave. Yep. In compensation, they're supposed to receive what's called the casual loading. So 25% extra, right? And that's supposed to compensate for the foregone entitlements and also the, if you like, the increased employment insecurity. Yep. And also the fact that you don't get notice of termination or redundancy pay. Yes? All right. So let's think about it in a practical way. I mean, if you're taking up a job, one is that you need to know what the national standards are. They apply across the board. But what's also important in determining your entitlements are what category of employment are you engaged in. Yes? Now, I said to you that these entitlements are with employees. Yes? Now, not all paid workers are employees. Now, so I'm introducing a bit of complication here, but it's an important complication to understand. If you're a paid worker, but you're what's called an independent contractor, you're outside the scope of all these laws I've talked about. Now, an easy example is this, okay? Your house, the plumbing system is broken, and you call the plumber to do some work to fix up your plumbing system. Yes? All right? Now, that plumber would not be your employee. That plumber will be an independent contractor. So Uber treats Uber drivers as independent contractors. Yeah? So you might seen, you might seen posters I've seen near my house, like, would you like to be your own boss? Yes? Yeah? Now, that is, of course, is a sort of popular appeal, but it finds a legal appeal. It's saying, it's basically, would you like to be an independent contractor? Yeah? Now, that places you completely outside, nearly completely outside of the system I just talked about. Yes? Now, but it's not so simple. I mean, I'll make 2 points here. Simply because the company or there's an agreement that says you're an independent contractor doesn't make you an independent contractor. I'll repeat that point. Yes? Okay? Just because let's say you and I, we come to arrangement, yes? Okay? I'm Uber, right? You're the Uber driver, right? And we sign an agreement, okay? An agreement says, you say, I agree that I'm an independent contractor. Yes? Doesn't mean you're an independent contractor, necessarily. Yep? The important thing of distinguishing whether a paid worker is an independent contractor employee is the amount of control the other entity has over the worker's paid conditions, working conditions. So let's think about Uber, all right? So Uber will be saying, hey, we have no control over our drivers, what kind of work they do, yeah, how they do it, and so on and so forth. They're independent contractors because all we do is provide a platform. They can choose when they want to go for a particular, take a particular job or not take a particular job, and so on and so forth. Yes? Can you see the argument here? Now, can you see the alternative argument why, for example, in the UK and also in the state of California, Uber drivers have actually been found to be employees? Uber sets the rates, yes? What else? So can you think? You're thinking about control now, right? Okay, you're thinking about what? So Uber is just saying, hey man, I'm just a software provider, yes? What's the deal? How can I be an employer? So the argument for them, the Uber drivers being employees, is that there is much more than just, it's not like, you're taking Microsoft Outlook, right? You start thinking about this, right? You're working in computer, you get Microsoft Outlook, and you start thinking, how can Microsoft be my employer? I'm just using this software to, do whatever word and so on and so forth. But the argument is much more than that, yes? But what you'll be thinking about, and this has not been fully tested in Australia, is whether there's sufficient control to make those workers employees. Now, some common issues. A worker should be paid for all the hours they work. Now, it might seem pretty obvious to say that, all right? But there are common problems arising in terms of Australian labour market, and maybe some of you even have experience. One is that it's illegal generally to have unpaid work trials. That's illegal. Yes? I mean, you can see the principle, right? You should be paid for the work. I mean, in a very limited sense, you might be a trial in a very short period. Maybe it could be like 10, 15 minutes, and so on and so forth. But something much longer than that, you should be paid for. Yeah? Now, we got to distinguish between a work trial and being on probation. Yeah? Even though you're on probation, you still should be paid, right? Yes? Because you're still performing work for the employer. Yes? How about this? You're working at a pizza restaurant, and the restaurant says, "Hey, I'll give you half your wage in money, but hey, I'll give you half your wage in pizza." Sound right to you? Right. Your entitlement is, well, you might laugh, but is this fanciful? No. Where have we heard this story before? La Porchetta. Anybody been to La Porchetta? The pizza? Yeah? Yeah. Okay, so this is public. I mean, this is all public knowledge, yes? Okay, so that's wrong. Okay, but it doesn't have to be pizza. It could be any other thing. Your entitlement is to be paid in money, whether it be in cash or by electronic transfer or so on and so forth. What about this? You are working as a waiter and in a fancy restaurant, and hey, when you're serving somebody, you broke some plates. Is it okay for the manager or the boss to deduct the cost of those plates from your wages? No. Okay? Simply because what you say, your entitlement to your wage arises because you perform work. Yes? Right. So you work, you get paid. Yes? Now, yes, you might have broken something, then the employer needs to basically bring a separate legal action to claim the damages for that. They can't just help themselves to say, I'm going to take your money off. Yes? Now, what about this? You're a cashier, and it's a bit short. Can the employer take money out from your wages? No. Same principle, yeah? But it's actually a further issue is really about proof and responsibility, yes? Even if the tail is short, the question becomes who is actually responsible, yeah? Okay. Now, similar kind of issue here in terms of customer leaving, yeah? Now, I'll end on this particular point and then I'll pass on to John. The other thing is very important is that in terms of your entitlements is that every employee in this country is entitled to a pay slip. Yeah? Now, why is that important? The pay slip is important because, as this slide says, it's a record of what you're being paid, yeah? It's also a record about what your job is, what award, also there should be information what award applies, there should be information of what leave entitlements are actually in your balance in terms of annual leave, personal leave, and so on and so forth. Yeah? And it's very important, especially if you actually are facing a claim of underpayment or so on, so on. You're thinking, like, hold on a minute, have I been paid the right amount? The pay slip is your proof, yes? Okay? So you're entitled to receive a pay slip. Okay, yeah. I've run through this very quickly, yes? Okay? But for further information, a really great, excellent place to start is the Fair Work Ombudsman website, yeah? And you see it up there in terms of the URL, yeah? All right, I hope this has been helpful. Yeah.
Okay, so thanks, Jutong. He's essentially been covering what I'd call the right to work under international human rights law. And so my task in sort of the 20 minutes or so I've got before the break is to give you an overview of what, in fact, international human rights actually are. Okay, can governments interfere with those rights? What protection you have, if any, and there's not much in Australia, okay, and then if something happens to your rights, what can you actually do? So it's a sense of what might happen at a very practical level as well. So we'll start with the first question, what are human rights? Any ideas or answers or thoughts about what human rights are as a concept? Generally speaking, there seem to be universal entitlements, so something that everyone gets, irrespective of your background, your language, your gender, your orientation. All human beings, by virtue of being a human, allows you to claim these entitlements. Okay, where do you find them? Well, under these things called treaties, international human rights treaties. Now, a treaty is a fancy name for essentially a written agreement between two or more states. So any idea about some of the human rights treaties that we do have? Can you recall or list any human rights treaties you may have heard of? No? Okay, I'm going to give you a few hints. There's one on children, the Convention on the Rights of the Child. One on women. Okay, there's one on racial discrimination. One against torture. There's also treaties on people with disabilities, migrant workers and their families, civil and political rights, and economic, social and cultural rights. So within each of those treaties, you get a whole range of rights according to your age or your gender, your race, or they're universal in terms of both the ICCPR and ICESCA, which are the civil and political rights, and the economic, social and cultural rights treaties. Okay, the important thing is to understand that unlike other sort of systems to look after you, like, for example, charity or benevolence, under a human rights approach, the idea is, at least in theory, that each of you get an interest, okay, a right and entitlement, and then you have a claim against the government. This is the important point. So a right allows you to make a claim against the government. So there's a rights bearer and a duty bearer as well. This is a theory, at least in practice. We'll see, in fact, whether it actually works out. So as I said up here, the government has a duty to protect your rights. Now, importantly, there are two broad categories of rights: civil and political rights and economic, social and cultural rights. Now, this distinction between the two types of rights is largely political. Okay, and it comes about from the Cold War. So in this category here of civil and political rights, those rights were largely the rights seen as being important in Western states. Okay, and then on the other side, you've got rights to housing, education, health, work, etc., which were seen as being of greater priority to largely the communist states throughout the 70s and the 60s. Importantly though, we've come to an understanding nowadays that both sets of rights are actually what's called interdependent and indivisible. That means that you can't enjoy one set of rights without the other. So there's no point you having a right to freedom of expression, which is a classic civil and political right, without there being a right to education, for example. Okay, and so Ju Chong went through largely the right to work and what Australia has done to try and operationalise that right in practice, give it some meaning. So even though these two distinctions are artificial, we still often talk in these terms, okay, civil and political rights and economic, social and cultural rights. So to go back over on these two classes of rights, we tend to think of civil and political rights as not requiring money to implement those rights. So the right to life, protection against torture, people assume that they don't require resources. They're seen as negative rights, things the government can't do to you. Whereas economic, social and cultural rights are seen as being positive rights, things the government has to do to enable you to enjoy those rights. So money for housing, money for healthcare. The reality is both sets of rights require money. So if my life's to be protected, what does the state have to do to make sure no one kills me? Any thoughts or ideas? What do they need? What do we rely upon when things go wrong in terms of violence in our societies? Who do we call? The police, exactly. And we hope the police force will come, hopefully. Sometimes the police are causing the trouble. The police will come and protect us, and if something's doing something wrong, they'll be prosecuted and hopefully go before the courts and if need be, being sent to jail. The point about that is these rights here also require money to ensure they are effective in practice rather than just in theory. Okay? So be aware of those distinctions. They're not always true. Now, more important question is, can governments ever interfere with your rights? Often an assumption is that we think rights are absolute. So we can never ever interfere or limit our rights. It's not quite that simple. Some rights are absolute. So for example, torture. The state can never, by law, torture you. Even if they think they make a confession or information that will save the world, it doesn't matter. We make no allowances for torture. As you know, many states still do it, but under law they're not supposed to do it as well. But many rights can be limited or restricted quite reasonably. The question is, are governments complying with the relevant tests? This is the really important thing here to be thinking about, which is often lost in conversations about rights. So if a government wants to interfere with your right to expression, association, right to privacy, freedom of religion, all those types of rights, then it has to satisfy these tests. There must be a valid law, okay? There must be a valid law under which they are acting. Then the government must have an aim which is legitimate, or we might call it a pressing social need. They can't just think we want to do it because we think it's a good idea. There must be some legitimate aim. So that might include, for example, public health, public safety, or the protection of the rights of others. Once the aim is established, we must then ensure that the measures are what's called proportionate. This is a really important test. Okay? So when we try and interfere with a right, we can only use measures that are necessary to achieve the aim. So the phrase I've used here is you can't use a sledgehammer to crack a walnut. Invariably, governments use far more force than is required to achieve their aim. And we can think about the situation of refugees and the way in which we've taken them offshore as being a disproportionate use of force to achieve aims around regulation and migration control. They don't have to do that to achieve the aim, but they choose to do so. They are using a sledgehammer to crack a walnut. Does that make sense, that idea? Doing more than you have to achieve your aim. So it's a really important point and something you might talk about in your small groups. Okay, any questions so far? All right, so think about things around restrictions on your freedom of speech. Again, governments can restrict what you say, but they can't silence you to the point where you can't enjoy your right at all. There must be some proportionality in those restrictions. Okay, now the more important question for us then is, well, how are rights protected in Australia and internationally? And this is where it gets a bit confusing. So I work in international law, which is this side of the graph over here. And under international law, every time a state ratifies or signs a treaty, they are supposed to, in theory, comply with those obligations. The reality is there is no international human rights court, okay, which is not a great story to tell you right now. But what do we have? Well, we have these things called treaty body systems, which are committees of experts. And those experts monitor compliance by a state with their obligations under international law. And the Australian government, for example, is required to report every 5 years. Now, as you'll see here highlighted, those recommendations aren't binding. Now, last week in the press, one of the UN officials was criticising the Australian government severely for failing to follow the recommendations of the committee bodies. Sadly, in fact, Australia is one of the worst states in the world for its non-compliance with recommendations from committees, which is one of the limitations of international human rights law, that we haven't got an enforceable system because it's all state-based, so we haven't got a court. So it makes international human rights law very weak in comparison with domestic law. And it makes it very frustrating for people like yourselves and for me. We want to go and enforce those rights because we've got no way of doing so. So what about what happens domestically? Well, there is no Bill of Rights in Australia. Okay, there is no Bill of Rights in Australia. We have a few rights in our Constitution. Does anyone know what those rights deal with? They're not many. There's an implied right to freedom of political communication. That's very narrow and doesn't really affect most of us. And there are also some rights regarding acquisition of property and rights regarding freedom of religion, but they are not particularly strong rights. So you might have come from other parts of the world where there is a very rigorous constitutional Bill of Rights. We have nothing like that in this country. In Victoria, we have a thing called the Charter of Human Rights and Responsibilities Act. And that lists what kind of rights? Only civil and political rights. There's no right to education, no right to healthcare. There are rights to freedom of expression, rights to protection against violence and torture. But again, sadly, there is no independent cause of action. So if the state does something to you and breaches your rights, you have very limited recourse under our Victorian Charter. Does that make sense? It's confusing in the sense that you expect there to be protection that's effective, but it's very, very weak. For whatever reason, this country doesn't like to actually accept the idea the state must protect rights effectively. So it leaves things often to the discretion of our agencies, or alternatively, it protects certain types of rights. So Jude Chong's presentation gave an example of how we protect the right to work. This is really important. So we may not have a Bill of Rights, but we have got protection in some areas. And one is in the area of workplace rights, and the other is in the area of equal opportunity legislation. So this is important. There is legislation that gives us some protection here. So the question is how? Well, essentially, equal opportunity legislation means that government agencies and private bodies, both those bodies, can't treat you differently on the basis of these attributes, these characteristics, these qualities. Race, sex, disability, age, orientation, political, religious belief, industrial activity, or employment activity. Now, there are a couple of things missing from this list. One of them is relevant to you. What status is missing? If you're a refugee, is that a protected attribute? Is that a protected characteristic? It's not listed, is it? You are protected on the basis of your racial group, on the basis of your political association, on the basis of your religious beliefs, but being a refugee per se won't give you protection. Nor will being homeless, nor being someone with a criminal record. So in Victoria we have what's called an exhaustive, a limited list of protected attributes, which is a problem for someone like me who wants to see everyone get protection irrespective of their attribute. Does that make sense? But we have a very limited list of protection as well. Okay, so then what does it mean though? Does it mean you can't treat people differently? Well, importantly, there are two types of discrimination in Victorian law. One is direct discrimination and one is indirect discrimination. So direct discrimination, okay, it's not treating everyone the same when they should be. So for example, it'd be like me saying in this classroom here, men can attend and women can't. That would be differential treatment, direct discrimination on the basis of your gender. Okay, you can't do that. Okay? Then there's also indirect discrimination, which is a bit more tricky and a bit more complicated. Okay? It's treating people the same when they shouldn't be. Okay? So for example, here I've given you are looking to apply for a job and the employer sets you a language test, okay, to everyone. And your language may not be as strong as other applicants, and they then say you can't get the job based on your English. But the ability to speak English isn't actually relevant or reasonable. Does that make sense? So you're all treated the same, but in fact you shouldn't be, because that differentiation isn't relevant to the work you're undertaking. If it is reasonable, if you have to speak fluent English, then that will be reasonable to undertake that discrimination, indirect discrimination. Okay? And this is often what happens, particularly with Indigenous people as well, where they may bear the burden of what appears to be equal opportunity legislation or directions, but in fact impacts on them more disfavourably. And this is the concern I would have, that we haven't got a federal system of rights protection so that everyone enjoys protection against direct or indirect discrimination anywhere, anytime. Here we're dependent upon the jurisdiction you're in, Victoria or federal, and then whether the attributes you have are the basis for the discrimination. Does that make sense? So it makes it harder for you to get protection. Even though, as you identified, it clearly can be indirect discrimination the way it operates in practice. But it highlights the weaknesses in our system as well. Okay, importantly as well though, there's a need, this thing called the principle of reasonable adjustment, okay, which means that companies, businesses, your employers sometimes have to make adjustments to accommodate your difference. All right, so this is very important, particularly in terms of whether you might have a disability or particularly when it comes to parents. Well, I'm a parent and I work full-time, but my partner is a parent who works part-time. And the issue there is whether her employer can actually be flexible with her working hours to enable her to help care for the children, whilst at the same time meeting the demands of her job. So there's no absolute right to get that flexibility, but if the employer can take reasonable measures to accommodate the difference, then they're required to do so. This is a very important thing, okay? So it gives you some flexibility. So historically, bosses had all the say, had all the rights, okay? And as Ju-Chong showed you, nowadays there is more and more protection for employees, okay, including now flexibility of work arrangements, particularly for mums, but also for dads as well when it comes to arranging time to get away from work to pick up the children, or if you've got a disability as well, to identify how to accommodate that disability. It has to be reasonable, so it can't put an unfair burden on the employer, for example, if it costs too much or they couldn't do the job. Now, importantly, I want you to think about what would happen if you think you've ever experienced a human rights violation in Australia. And they happen all the time. This is the reality. And the other reality is that often there are no means of a remedy, which is disappointing but true. Having said that, if you have a concern, okay, here are some numbers to call and get some advice either from the Victorian Commission on issues around Victoria, the Human Rights Commission in Sydney, which is around Australian human rights violations. There's an NGO in Melbourne called the Human Rights Law Centre, which is very, very good as well. And then you can also contact your community legal centres, which will give advice around these issues also. And it's worth thinking about that if you've got concerns about any of these things in your work. This is a very, very big topic, huge. I'm into day 4 of a 5-day course just teaching children's rights. To give you a sense of how big these topic areas are, I've just tried to map out a few of the key issues for us in Australia. The reality is we have a very weak system of protection of rights in Australia, which is disappointing for me, possibly disappointing for you, but there are some avenues where we do have redress, and there are some areas where we have well-developed protection around equal opportunity and areas like the right to work as well. So on that note, I'll say thank you. Thank you for coming, and good luck with the rest of the evening as well. Okay, thanks very much. Cheers. Well done.